this is John McGuire at the McGuire Law Firm, and in this video I want to talk about a letter of intent in the context of a business acquisition. So recently I had someone ask me, what is a letter of intent? And generally, this is a letter used when you have a purchaser and a seller that are looking at entering into the sale of a business or business assets. Generally what will happen is the business owners will meet. Sometimes they'll discuss issues in general. Hopefully they've entered into a non-disclosure agreement prior to the letter of intent. And then they will move forward with the LOI. So the LOI, which is letter of intent, will basically outline the most pertinent issues within the transaction. It will state the parties, generally the purchase price, certain terms, sometimes the closing date. Often there will be a confidentiality clause within the letter of intent. Generally, I think it's advisable to probably enter into a non-disclosure agreement prior to the letter of intent. You may be disclosing certain issues in the letter of intent prior to executing that agreement, whereby the confidentiality clause would not be valid. Hence the reason to go to a non-disclosure or confidentiality agreement prior to the letter of intent. Generally, I think that the more you can hash out the issues in a letter of intent, sometimes the quicker the actual asset purchase agreement or stock purchase agreement may go. It may go smoother and quicker. So I think it's a very important document and important to understand what it is used for. Most of the terms and issues within that agreement in terms of a letter of intent are not going to be binding, but it's to try to have a meeting of the minds so that the parties can move forward quickly and efficiently, without wasting time, if in fact, the deal can never be consummated. So if you have any questions in regards to this document or other business contracts, please feel free to contact the McGuire Law Firm. Thank you very much.